Welcome to our discussion on the basis of U.S. law. U.S. law combines two kinds of law: common law, which is made principally by judges reaching decisions in cases, and code law, enacted primarily by legislators, and often referred to as statutory law, and by chief executives. Although the U.S. legal system has roots in a common law system, most legal disputes today center on disagreements involving the interpretation of code law. Civil law is the body of law dealing with the rights of private citizens. In civil law cases, there is a conflict between private individuals in which one party alleges that some action or inaction by the other party, the defendant, has caused harm to him or her. Criminal law is the body of law dealing with conduct considered so harmful to society as a whole that it is prohibited by statute and is prosecuted and punished by the government. Criminal law cases are always filed by the government against the defendant. Because criminal cases are concerned with the breach of an obligation owed by the individual to the larger society, criminal cases always involve either a state government or the national government, though sometimes civil cases can involve a government entity. For example, when the baseball legend and home run record breaker Barry Bonds was indicted for allegedly having lied to federal authorities investigating the sale of steroids, the criminal case was filed as the United States of America versus Barry Lamar Bonds. In contrast, civil cases typically pit individual against individual, as in Dawn Simagankar, also known as the Boudoir Queen, versus Courtney Love, a case in which she alleged that celebrity Love used Twitter and other online platforms to publish delusional accusations and lies and threats of harm concerning the fashion designer. Civil cases typically center on the breach of some obligation owed by one individual to another. The most common civil cases are concerned with the family, a contractual matter, or a negligent injury to a person or property, also known as a tort. Laws created by courts through the cases they decide is called common law, and it binds all courts considering similar cases in the future. To understand how common law functions in the American legal system, consider the 2005 case of Terri Schiavo, the woman at the center of a very controversial debate about an individual's right to die. When Schiavo became ill and collapsed in 1990, her brain lost oxygen and she lapsed into what doctors call a persistent vegetative state, or PVS. A person in a PVS can breathe on his or her own, but has very limited brain activity and requires artificial food and hydration. Terri remained in this terrible state for years. Then, in 1998, Terri's husband, Michael Schiavo, asked the Florida State Court to issue an order that would allow the discontinuance of artificial food and hydration. When the state court issued the order, Terri's family filed a motion to block the removal of the feeding tube. Over the next 7 years, the disputing parties battled out the case of Terri Schiavo in the state and federal courts. The courts had to determine whether Terri would have wanted to terminate life support. That determination must have been difficult for the judges, who had to puzzle out Terri's intent by listening to her loved one's testimony on Terri's comments before her accident about how she would have wanted to live if she were ever in such a state. Competent individuals have a right to discontinue food and hydration without government interference. The Supreme Court recognized this right in the case of Krugin versus Missouri Department of Health, 1990. The Krugin case concerned Nancy Krugin, who also was in a persistent vegetative state, and for whom the family sought to discontinue food and hydration. The state of Missouri had intervened, arguing that the family had not provided sufficient evidence that Ms. Krugin would have wanted this termination. Ultimately, however, the family prevailed. The Krugin case is important because it created new law. The Supreme Court's decision in this case established that the Constitution's Due Process Clause, which states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law," protected the right to discontinue food and hydration. This right was assumed in the Schiavo case. The courts were not trying to puzzle out whether Terri Schiavo had the right to discontinue food and hydration, since Krugin had already established this right. Instead, the judicial deliberations focused solely on whether this was a choice that Terri herself would have made if she had been competent. The court decision that established the right to discontinue food and hydration is now part of U.S. common law. England began using the common law as a means of unifying the country in the 1100s, when local courts began to write down this national or common law to make it easy to use. Nobles soon realized that the law might be applied to limiting the power of the king and could protect them against unfair and arbitrary actions by the anarchy. Most significant in the creation of common law was the Magna Carta of 1215, the first document to list the rights and protections granted to individuals in England. The Magna Carta is one of the core documents in the evolution of constitutional law. In the evolution of the American judicial system, the colonists relied on the principles of stare decisis, a Latin phrase that means let the decision stand. Stare decisis means that in deciding cases, judges must abide by the legal precedent, that is, the legal authority that earlier cases established, even in the instance of laws handed down hundreds of years before in a society that was far different. The principle of stare decisis ensures that common law is not very quick to change. Stare decisis also ensures a consistency of legal expectations for individuals and the legal community. Common law was the predominant form of law in the United States in the 19th century. By the early 20th century, rapid changes in society and the economy demanded much faster responses in the law than what common law could provide. Legislators in Congress and the states responded to those changes by creating laws to regulate the behavior of individuals and organizations and to deal with a vast array of new issues. The kind of law they developed is known as code law. Code law differs from common law in that it traditionally is formulated by legislators through statutes, whereas common law is created through judicial decisions. A similar, continuously changing social environment prevails today. Because of the steady flow of change and the fast pace of contemporary life, particularly due to non-stop technological advances, the prior body of law has become inadequate to deal with unprecedented developments in commerce, communication, and even crime. In creating code law, responsive to these new realities, legislators have had to become more knowledgeable and specialized about the topics of laws they write. They have had to rely heavily on experts, police attempting to enforce the laws, business and industry leaders, other specialists, to help shape how laws are written. Code law functions very differently from common law. When legislators or executives make law, they can move quickly in response to some pressing crisis or problem. They can decide to change course and even take a totally unprecedented approach to a situation.